the order in docket 8186 regarding the Village of Morrisville Water and Light request for amended certificate of public good and approval for a 15% ownership interest in the transmission line jointly owned by Johnson and Morrisville.
Objection only as to relevance.
Well, I'll link. I'm trying to just establish what what the document is, but it's relevant because it goes to the use of the line, and it's going to go to Craig Mayott's statements that are adopted by the order related to the construction when the line was constructed.
Yeah, I'm fine. Overruled. Let's continue on.
All right, thank you. And were you aware that in that order they adopted Craig Mayott's statement that the line was built around the 1950s?
I never saw the document until we got involved in the process that we're in now. So this document, I read it in its entirety not terribly long ago. At the time it was being produced, I had no knowledge of it.
If Craig Mayott previously indicated that the line was constructed in approximately the 1950s, you don't have a reason to dispute that, do you?
What part of the document are you referring to?
Might need to put that back up on your screen.
Yep. Page 3. Yeah, I will. Hold on. So I'm referring to page 3, paragraph 3. Hold on a second. I think there's a footnote. Hold on just a moment. I think I have to get a different document. Just a second. Sorry about that. So I'm referring to that same document, the EXPET EB2, and I'm just referring to this numbered paragraph 3, where it says the B22 line was originally constructed in 1918. No CPG existed for the original construction as it predates 248. On December 12, 1994, the board issued a CPG authorizing the reconstruction of this line. The 1994 CPG, the 3329 line, was originally constructed in the 1950s, and no CPG exists because it predates 248, and that references a Mayotte response. Do you see that?
I see it.
Yeah. And you don't have any reason to dispute Mr. Mayotte's response that was adopted by the commission, finding that the line was originally constructed in the 1950s, correct?
I just want to object only to the extent this appears to be the commission's order and it's citing to a response. The response it's citing to is not in front of Mr. Heller.
I think more of the way I'm viewing this question is differently. Mr. Heller, does this information cause you to reassess your opinion that the line was installed in 1949?
Well, I don't agree with the statement that it was installed in 1949. And as far as the sentence goes there, I have difficulty separating the context there. I mean, it's talking about a date, but it's also talking about when a CPG existed. So I hesitate to comment on this. Like I said, I was not involved with this document. I'm not really sure how to reply to that. There's some parts of this I just am not familiar enough with to offer a confident answer.
All right, so just for my benefit, can you just rehash then? When do you think the line was installed?
There
Or
was a
more
request-
specifically, when do you think the two poles on the Adams property were installed?
They were reinstalled in the 1940s as part of the line that originally served the Mansfield Electric Train Station, which was a request for power in the 1900s, early 1909, I believe.
And what's the basis for that history that you provided? How did you learn that?
Through company records and local history and my involvement with the maintenance of our transmission line.
Understood. Okay. Mr. Simon, you can continue with your questions now.
Do you know when the railroad stopped operating?
Not exactly. I want to say like 1911 or maybe as late as 1930. I know that's a wide range, but it's not really my area of expertise. I mean, it's not like I served at that time or anything to do with the railroad.
No,
so to
sure,
speak.
but-
I wasn't a railroad employee.
No, I understand, but I thought it was pretty common knowledge that the railroad stopped operating at the latest in 1930s, so you wouldn't have the same configuration. as
One of my
1930s.
dates was correct then.
So, referring to Scott Johnson's rebuttal testimony, please confirm, well, I'm gonna strike that actually. In your April 11th, 2024 affidavit, and I'll put it up on the screen to, if it's gonna help. You testified to the line being built. We're still on that same issue. Never mind, strike that. There's no documentary evidence in the record to establish when the current 34.5 kV transmission line was actually constructed, is there?
I'm sorry, Mr. Simon. Could you slow down, repeat that again for me?
Yeah, there's no evidence in the record to establish exactly when the 3329 line with the 34.5 kV transmission capacity was installed, correct?
I disagree.
What's the documentary evidence that you're aware of that explains when exactly that was installed?
So let me back up just a little bit. Are you asking me if there's any evidence of record in this proceeding that would establish that?
Correct.
Oh, can you put any of the documents up that you're referring to?
Well, I can put any of the documents up that you want to refer to. I'm just not aware of any. I'm wondering if you are aware of any that actually established that time frame as the, or whenever the time frame was when they were actually put in their current configuration.
I understand the question. I'm not sure. I don't remember if there was a document submitted because there's been a lot of them that I've reviewed. I guess I can't answer your question.
You were asked in discovery to produce any documentation of the construction of the line, and nothing was provided in response to that, correct?
I was asked what?
You were asked in discovery to produce any documentation of establishing when the line was constructed, and there's no documentary response to that request, correct?
I think that's correct. I think we provided some documentation with dates.
All right, I'm gonna,
So yes, Bryce, now that, or I'm sorry, Mr. Simon, now that we've had some time to talk about it, the request by the electric train station was for a transmission line. That was 1909. We provided that documentation.
okay, so I thought I was trying to ask, and I'm sorry if I didn't ask it correctly, but I was trying to ask about documentation of the current configuration of the line, the 34.5 kV line.
Again, I would have to review the documents because there was many of them that we submitted as to a date that the 34.5 was adopted.
All right.
I'm sorry, I can't answer better than that for you.
That's right. Prior to the petitions being filed, would you agree with me that Morrisville Water and Light did not have the right to enter onto the Adams property whenever they wanted to maintain the poles? You had to ask the
My
Adams
understanding.
permission?
I'm sorry, I
ahead.
interrupted you.
No, please, go ahead.
Yeah, I don't think I heard all of what you were asking me. Could you repeat it, please? I'm sorry.
Sure. Do you have in mind a belief as to whether or not Morrisville Water and Light, prior to the filing of these petitions, had a right to come onto the Adams property without their permission and maintain the poles?
Yeah, it's a good question. My understanding has evolved over the life of my employment here. When I originally started to work here, I thought we had the right to inspect and patrol and maintain our line. I understand now a lot more legal my understanding of the legal right to get there as it's evolved. So my understanding since we started getting better access has been based on what I've been told about, I believe it's called Title 30.
Okay. Now, Morrisville Water and Light is through its easement seeking unfettered access to the lines and poles on the Adams property, correct?
We're seeking access. I'm not sure I understand your use of the term unfettered.
Well, I believe you use that word, that you're seeking unfettered access. You don't recall that?
Well, I recall using it, but I'm beginning to understand that there's some disconnect in everybody's use of vocabulary. I'm learning a legal vocabulary and I'm hoping that you're learning an electrical vocabulary. So I'm trying to understand and make some good communication happen here.
I'd like that. And actually, you were there when Mr. Johnson was testifying, and he mentioned that that there is a certain term of art that's in the easement. Do you recall that testimony?
I heard Mr. Johnstone make reference to language having a certain art to it, yes.
Do you know what the term of art is relative to the word renew as used in the easement?
In the way it relates to my business, poles and wires, construction, maintenance, renew would be to bring something that's pre-existing up to correct operating conditions when it is no longer, when it's getting to the end of its life, yeah.
Different from replace, fair to say?
Different than
Replace.
replace.
Yeah.
I don't know how you can renew something without replacing it. How do you renew a pole without replacing it when it's no longer usable? So the two are interchangeable in my world.
All right, that's what I'm trying to understand. Thank you. Do you agree that a utility company must comply with property rights, safety rules, environmental limits, permits, and PUC orders and other state laws?
Yes, I understand.
And the proposed easement does not identify a specific access route onto the Adams's property, does it?
We've talked about several different versions of the easement. Can you provide me with the one that you are referring to?
Yep, I'm sharing it now. So this is the PETSJ SUP 1. That's the easement that is the current easement under consideration as far as I understand it. That does not identify a specific access route, correct?
I would have to review it.
Well, there's certainly no reference to a survey that identifies an access route, correct?
You want to point out the language that you're thinking about?
So I'm going to highlight this third paragraph. Just says permissions herein granted to enter upon and pass over the grantor's land for access thereto and to enter upon said strip for all the above purposes and all purposes properly incident to this easement. So there's, at least in that area, there's no limitation on where the company could access the land, the property, correct?
You're asking me to interpret something in a legal fashion?
Nope, I'm just saying that the meaning of the words on the page does not have, or those words on the page does not have an identified specific route, does it?
I'm just going to object at this point. This seems cumulative of Mr. Johnstone's testimony. I don't see that this does anything that's not cumulative.
I guess I'll also just point it out that I can read the words on the page, and I understand where, to the extent that it describes the access. So I don't know if you need to keep making this point.
All right, Mr. Howard, in 2015, Morrisville Water and Light entered the Adams property with permission from the Adamses, correct?
Mr. Simon, I'm sorry, I'm having a little trouble hearing you. Can you slow down just a little bit? I apologize. I am very hard of hearing. I do wear hearing aids.
In 2015, Morrisville Water and Light entered the Adams property with their permission, correct?
It would have been somewhere in that. I think it was 2016, Mr. Simon. There was time that we were there. And the question again is, did we get permission to go on the land?
Yes, you did get permission from the Adamses, and maybe it was 2015, but you got permission from the Adamses at that time to go on the land, correct?
Okay, so 2015, yeah, okay, that's correct.
You got their permission to go on the land, correct?
I think that was for tree trimming
So the
initially.
answer is yes, you did get their permission, correct?
Is that my testimony you've got in front of me?
Yes.
Okay, can you just scroll down a little bit so I can read what it is that you're referring to?
Sir, do you recall going on their land with their permission?
I think, just let me finish reading it so I know what you're asking me, okay?
I don't have all the time in the world, so I'd like to move on.
I'd like to be able to answer your question accurately. So you're talking about a 2015 and yeah, you need to scroll down just a little bit more for me, please.
All right, sir, it says during the above mentioned 2015 visit to the property, MWLD arranged with the Adamses time for the necessary repairs and pole replacements to be made. So your testimony indicates you did cooperate. The Adamses, at least on one or two occasions, cooperated with you relative to going on their property. Is that fair to say?
Yes, that's fair.
Okay. And you did, Morrisville Water and Light did enter the Adams property and did trim some trees, correct?
Yes,
And you testified that Morrisville Water and Light arranged with the Adamses a time to come back for further trimming, correct?
in this particular instance, yes.
And you did not, Morrisville Water and Light did not return because of widespread power outage based on your testimony at lines 17 to 20 on that page, correct?
That's correct.
So that first missed return date was caused by Morrisville Water and Light being unable to return, not by the Adamses refusing access, correct?
It had nothing to do with the Adamses refusing access. That's correct.
And after the December 22 storm, the Adamses again allowed Morrisville Water and Light onto the property for tree trimming, correct?
Well, it wasn't a timely access. We were allowed to come back at a time that they agreed to. We couldn't gain access at the time that the problem was initially reported.
And then you did again gain access and you did again make trimming or do tree trimming, correct?
At the agreed upon time, yes.
So this is not a case where Morrisville Water and Light has never obtained access or always been denied access, correct?
I'm sorry, can you just slow down a little bit? I'm having a hard time keeping up.
So this is not a situation where the Adamses have completely denied access or where Morrisville Water and Light has been completely unable to gain access, correct?
The Adamses have not denied us access at all times. It's just a matter of timely access. We have been asked to come back at a time that was more convenient for them. And when I've got trees burning the conductor down and an unsafe situation like that, it would really be a better situation if we could address that then and make a timely correction to the problem. That's timely access is really important.
And in regards to cross exhibit EE that's up on the screen, that incident that you're talking about with the fire, that issue was ameliorated because you were able to clear all those trees on the bank across the fence from the Adamses property, correct?
No, that's not correct.
Well, all the trees that were along that fence line near that pole that's there are now gone, right?
They're gone now. Yes, that's correct.
All right, thank you. And are you saying that those were not the trees that were causing problems?
Well, there's more to this than the question that you're asking reveals. If I may, Mr. Simon, add that when all those trees were on the bank, they were preventing us to get to the trees that were overhanging the line. So there was probably 30 feet of mature trees between the wires and that upper parking lot. And there was no way we could cut through in a timely fashion without permission from the landowner, a swath 30 feet wide of mature trees to access a few branches from the Adamses driveway that would have taken just a few minutes to drive our truck up to and remove those branches. So what you see there is the result of the neighboring landowner initiating a call to myself saying, hey, we would like these trees removed. Can you work with us? And I said, well, we'd be happy to work with you. What would you like done? And they said, we'd like all the trees removed on our property.
So you were
that's
able
what
to
you
do
see.
that. You were able to do that without going on the Adamses property, correct?
There's a sequence of operation here that needs to be explained.
And I'm not asking about the sequence of operation. I'm just asking you, those trees that were threatening the line in that location where EE depicts your pole, those trees were completely removed by going on the neighbor's property, not on the Adams property. Fair to say?
Fair to say.
Thank you. Now, you reference in your testimony the December 17th, 2022 interruption report, correct?
I did.
All right. And isn't it true that in that report, it indicates that Morrisville Water and Light's equipment north of the Adams property had a malfunction or didn't function perfectly?
That's not correct.
Your equipment faulted out and remained closed for 15 minutes instead of 10 minutes, didn't it?
That was a occurrence that needed to be investigated.
But that had
That's
nothing
just
to do, that was a problem with your equipment, wasn't it?
Objection, it sounds like we're discussing a document. I note in the court, in the hearing officer 6-4 order, page 12. If you refer to any document during your questioning, you must share documents. I would just suggest that we share the document so we can be clear and accurate.
I'm gonna move on. You did not attach an engineering study showing that the establishing through scientific evidence or the like that the Adams property requires a 50-foot easement, correct?
An engineering study determining that what was required?
50 feet is not required for engineering purposes, correct? 50-foot wide easement, you can operate the line with a narrower easement than 50 feet as you do at the Stowe Tile building with a 25-foot easement, correct?
That's not correct.
You're not aware that there are places where your easement's only 25 feet?
Very aware. I'm very aware of it. I don't agree with it. It doesn't make operating and maintaining that line any safer or any easier. It makes it more difficult and costly and timely. It doesn't make it more. Go ahead.
But you do operate the line in that area, correct?
Define operate.
It's working right now, isn't it?
It's working, but that doesn't allow us to get in there and do the maintenance and do the operations in a way that is timely and safe.
Okay,
And
thank you. Did you attach a turning radius study for the equipment that you propose to use at the Adams property? Or have you obtained one?
I'm sorry, Mr. Simon, you'll have to repeat your question.
In respect to your need to use the Adams property up to various widths, do you have a turning radius study for the equipment you propose to use at the property?
And a study on the type of equipment that's going to do the tree trimming?
Yeah, to establish how much space you need. To establish what the turning radiuses are and how much space you need to do the work.
A study to do that? I've never had to do a study on what kind of equipment. It depends on the type of clearing we're gonna do. Is it gonna be mechanical? Is it gonna be done by hand? You know, there's no casting concrete approach to vegetation management. I know that what the requirements are in order to get heavy equipment down a right of way.
And you don't have any analysis of the alternatives to a 50-foot easement at the Adams property, do you?
An analysis?
Yeah, in the testimony I've seen, you basically say that 50 feet's what you'd like. It's convenient, it's helpful, but there's no scientific sort of study or any other analysis to determine what the different options are and why one is preferable over the other.
No, that's not correct. I don't
Objection.
agree with that. There's all kinds of, go ahead.
I think it's appropriate for Mr. Simons to ask what analysis was done, but it sounds like we're testifying about what is in the pre-file.
Well, I'm just asking, well, we've already talked about the fact there's no experts reports. So that would include there's no expert report as to the different alternatives relative to various widths of easement, correct?
Objection.
Exactly.
We're talking about expert reports. We're referring to analyses. It's unclear which we're actually talking about.
I said there aren't any.
All right, let's just answer the questions. Are there any expert reports? And the answer is no, and you don't think they're necessary, that's a fine answer.
Define expert. Does 40 years worth of line work?
I'm gonna withdraw the question.
interaction
I'm not gonna answer the witnesses' questions. The site plan that's been produced by Land Integrity, that does not include all the trees that Morrisville Water and Light plans to clear on the Adams property, correct?
That's a difficult one to ask because
All right,
How is-
if you can't answer it, then we'll move on. So regarding the 50-foot easement, that's preferred and customary, but that's not the same as the minimum necessary for this property, correct?
that's not correct.
Now, Morrisville Water and Light intends to replace the 2 poles on the Adams property, correct?
Well, poles, cross arms, and insulators, the supporting structure, we would plan on replacing.
And there's been some discussion today that the old poles are about 40 feet long and the new poles will be about 45 feet long, correct?
That's correct.
And the cross arms going from 5 feet wide to 10 feet wide, correct?
That's correct.
And the insulators are going to be upgraded, correct?
Define upgraded, what do you mean?
Well, you'll certainly replace them, right?
They have to be replaced, yes.
And they'll be replaced with bigger ones, right?
Physical size, or what do you mean? Bigger?
Whatever you mean by bigger.
I didn't say that they were gonna be bigger, did I?
Are they going to be larger in size?
So
Just yes or no. Are they going to be larger in size, please?
they're gonna be, you haven't seen a insulator that's on those poles produced in 75 years. They don't look the same, they're not the same material, they're shaped differently. Well, there's some on the poles just off the respondent's property that they would be very similar to,
All right.
already in
So
existence.
So the goal of this proceeding is not to maintain the line, the poles, the cross arms in their current configuration. It's to increase the size of that configuration, correct?
Objection, characterization.
Response?
Sorry, what was the objection?
It's characterization. You're also asking a legal question.
I'm not asking a legal question. I'm just asking if he's going from one thing to the other, and I don't understand what the objection characterization is. I'm cross-examining him. I think I'm allowed to characterize things and ask him to agree to it.
Yeah, leading testimony, leading questions are fine on cross, right? I mean, he can try to get him to say yes to whatever, but he doesn't have to agree to it if he doesn't agree with it. So I think what I'm struggling with the question is when you say larger, as you mentioned, like there are multiple interpretations of what larger means, and it's not really clear what we're talking about here. I think what I heard Mr. Heller say is it's very difficult. It might be difficult to sort of strictly compare the physical size of the 2 units just because they look completely different. What I think we're trying to get from Mr. Heller is, will the new insulators allow the line to operate at a larger capacity? That's really
No,
what we're
they
getting
won't.
at. No, they will not.
They
Okay,
won't.
can you explain why in a short statement?
There are other limiting factors on the line that would prohibit the voltage to be increased or the current carrying capacity to be increased.
What are those?
What are those?
Yeah, what are those other limitations?
There are multiple limitations. You've got 8 miles of line that are already constructed at a operating limit that would have to be reconstructed in order for the line to operate at a higher capacity. 8 miles of line that have to be rebuilt.
Does the line currently operate at the full 34.5 kilovolt capacity?
It has at times, not all the time, but it has reached its maximum on occasion.
And would the changes you're proposing for the Adams property help it reach that maximum more frequently?
No, it's already designed and it can't exceed its maximum without some serious repercussions. The line would not continue to stay operable. It would have to.
Will it allow, if the changes that you're proposing to the Adams property are made, will it allow you to move more power through that line than you're moving now?
Not beyond its present design capabilities.
I'm not asking about its present design. I'm asking about practice. In practice, what you're doing now, will that increase if your repairs or if what you're characterizing as repairs are allowed?
Absolutely not.
Uh, would you agree with me that the improvements that you're talking about making to the Adams line will provide Morrisville Water and Light with operational advantages that you do not currently have?
Yes.
And in the Adams rebuttal testimony, they identify NESC clearance requirements and they state crossarm width is based on a formula and table, not a static requirement. Did you review that testimony?
Did I review that testimony? Yes.
Yep. And you have not provided your own calculations, have you, as to those NESC requirements?
It's a rather convoluted and complex calculation, and I did not provide it in its entirety. So I would have to say, no, I haven't.
But you've testified that you need 40 inches of width but spacing and 18.5 inches of height, right? Sag?
That's just a part of many moving parts that determines the spacing on the crossarm. And I'm happy to go into it with you if you'd like.
Well, do you have a mathematical formula that you've actually performed to determine these required?
It's a series of calculations. It's not just one formula, and it can be, you can reach the answer without necessarily using an equation. There are multiple paths to the determination of the spacing of the conductor on the crossarm. And I'm happy to discuss it with you, just give you a description of the process.
Well, you said you needed 40 inches and what the easement or what you're proposing is 9 feet and 4 inches, correct?
The 40 inches is one criteria. But there's
Just a
other.
point of clarification. When we're talking, that's 40 inches spacing between the conductors, correct? And you've got 3 conductors, so you need at least 2 40-inch gaps
Spaces.
between, spaces.
So this is a great conversation. I'm glad that we're having it. But you've got working space, which is one space that you have to provide for. There's the space that you have to provide for a worker on the pole. And then there's clearances that are electrically required that have to be provided in order for that to operate properly. And the information that was provided by the respondents, I appreciate their efforts. But I don't agree with the table that they used. I don't agree with this conclusion that they came. So there is a spacing that is required that is in excess of what they have suggested in their testimony. And 40 inches is that.
Sorry, I didn't mean to interrupt you.
40 inches is both a working clearance and electrical clearance that happen to be very close to the same measurement. Like I said, it's a kind of a convoluted process. I didn't put all that information into my testimony, my written testimony.
And did you hire or consult with a professional electrical engineer to help you determine what clearances or what proportions are required under the NESC code?
It wasn't necessary. It's not required. I was able to come to that conclusion based on my training.
Yet, I guess I don't understand why wouldn't you put that supporting information into your testimony?
Because I'm not sure everybody would be able to follow it in that description, in that platform.
But you understand that you were not disclosed as an expert on that either, right?
I'm not disclosed as an expert. Is that necessary? I mean, I'm required to know how this works.
Well, I understand, but don't you think that someone with a doctorate in electrical engineering could explain a little bit better what is actually required under the NESC code?
I'm not the world's best teacher or communicator. I'm sure there's lots of people out there that could do a better job of it than myself.
When you replaced the poles on properties near the Adamses, did you install 10-foot cross arms?
I would like to think that that is what we would be able to do. That is the standard, and that is the framing on all the other poles on either side of the Adamses, and that is the intended goal for the replacement of those poles.
That was not done though on the south side of Cemetery Street, correct? Where you replaced
There-
that pole?
There are. At what time are you referring? What
23
time?
Cemetery Street.
23 Cemetery?
Yeah, the pole just to the south of Cemetery Street, just to the south of the Adams property. That's not a full 10-foot cross arm, correct?
It's not a 10-foot cross arm?
That's what I'm asking. It was replaced in 2024 with not with a narrower than 10-foot crossing.
I would want to field verify that, but that was the construction standard. I was not the electric superintendent in 2024. I'd want to double check what's there. But do you have evidence that it's not a 10-foot cross arm?
I mean, I can show you a picture, but you don't have any evidence that it's at least 10 feet, do you?
That's the standard that we've built to on the 3329 line. I don't know a reason why it would be less than.
I can show a picture, but I don't think it's worth it. All right, so you have the Adams testimony, again, I understand you had some concerns with it, but they state that a 45-foot pole creates additional vertical clearance that may allow higher operating temperatures, greater sag, and increased current flow. Do you agree with that?
We're getting into some really technical hair splitting here. The
Well,
overall operation of that line is not going to be changed by taller poles, more air circulation, more spacing. You're limited by other factors than just two poles in a facility that's 8 miles long.
You've not provided a load flow study showing the taller poles will not increase operational capacity, however, have you?
No, I haven't.
And do the existing poles on the property need a full 18.5 foot sag?
That is one factor that we have to consider, and they presently conform to that standard, but not all standards.
So they conform to that standard in their current configuration.
For that standard alone, they are in conformity. Others, they are not.
And you've not provided an ampacity analysis showing the additional pole height has no effect on capacity, correct?
That's correct.
And your affidavit, I think it was in support of declaratory judgment, states that any NESC requires minimum clearance of 18.5 feet above a flat unobstructed surface for transmission line of this voltage, correct?
That's correct.
And you did not testify that the existing line currently violates that clearance. I think we just talked about that. So I'll strike that. You did not provide a measurement showing the current conductor clearance though, did you?
A measurement?
Yeah.
Of the 18.5 foot clearance on the respondent's property?
Yeah.
We would have to have access in order to make that measurement.
Right. And you haven't asked for access to make that measurement, have you?
Excuse me?
I'll strike the question. You also, hold on some more. So those poles that have been operating since, or have been in the ground since 1949, those have complied with safety requirements sufficiently to continue operating, correct? You haven't been shut down, have you?
because of those two poles.
Right.
We have shut down because of those two poles.
No. What I'm saying is that there's no violation of any SC code, any SC codes that is causing you to have to depower the line.
Well, I don't know that those distances are, no, that's not correct. That spacing is not sufficient for 34/5 operation. Did that insufficient spacing contribute to some of the outages we've had on that line? I don't have a way of proving that.
Are
But
you able to tell us which edition of the NESC that you are relying on relative to your testimony?
I'm relying on the clearance section of the NESC as it is described in some tables that I cannot quote or cite the table number off the top of my head, but it's the clearance section of the NESC, and it's not just one table. This is a document that has to be taken in its entirety. Because
which version
references another document, which leads you to a final conclusion. And the table that has been referred to is not the table that you start with, it's the table that you end with. So
which edition of the NESC code do you use?
I've had to use two because this thing has carried on for so long. The 2017 expired, and I'm now presently going through the 2026 version.
So which is your testimony based on?
I believe that the 2016 reference is the same as the 2018 version is the same as it pertains to clearances as the 2026. But the only way I was to know that was if I got the latest version. So, like I said, it's a complicated text to be referencing without some prior experience with it.
To your knowledge, if the easement is granted in its current form, would Morrisville Water and Light, do you believe Morrisville Water and Light would have the right to install guy wires?
If that is the language in the final version that is accepted, and that's the language in it, yes, we would have the right to install guy wires. Presently, there's no need for it.
Have you done an analysis, an engineering analysis, as whether guy wires would be required at the new configuration?
We're not making any changes, so there was no analysis required.
Well,
There's
no,
no
but
changes being.
to go 5 feet higher and to make the wider cross arms, have you done the analysis as to whether that will require guy wires?
Yes, of course, and that's not required. And the analysis is based on 40 years of experience building lines and having training in the building of those lines, going to school, building the stuff, seeing that it works. No analysis is required to install guy wires on poles that never needed them in the past, and you're only going 5 feet taller.
You testified that the proposed easement would be that if you're granted the condemnation, that the use of the property would be substantially unchanged from the current use except for the legal right to enter. Isn't that what you said in your testimony?
Based on what I have seen down there for the landowner's use, and I haven't seen it all, there would be no change to the way they've been conducting business. If the way they're conducting business down there is the same as it has been for the last 15, 20 years, then they're not going to notice any difference to that easement. They've got plans of putting up a skyscraper, well, then the easement's going to prohibit that.
Well, but if they have plans to do anything in that area, like parking cars or, doing more landscaping or grading their driveway, all those things are prohibited in the easement, right?
No, they're not prohibited. I mean, there's power lines around parked cars all the time, and we work around that all the time. I think there's a lot of communication that needs to be done around this easement to satisfy both parties' interest in the language and the rights. So there's a lot of work to be done in that regard.
But wouldn't you agree with me that whatever the easement actually says is the language that's going to be applied in the future by people other than yourself?
Whoever comes after us are gonna have to have an understanding of the language in a way
Right,
that is preserves continuity. Yeah, I agree.
Right, so whatever whatever the maximum impact that you're allowed to have on the land under that easement is the impact that we can expect could occur. Isn't that fair to say?
That's reasonable. Yeah, I agree with that.
And that easement creates new written access rights that you don't have now, correct?
Well, I think that's what this hearing's all about.
Right, and it would create new written vegetation clearing rights that you don't have now, correct?
They would define the rights that both parties have in a way that is clear.
So the easement does more than preserve the status quo, it grants new rights, fair to say?
Objection, we're getting into the legal portent of a legal document. And I
I'll-
think we went over
I'll-
this with Mr. Johnstone.
I'll withdraw the question. You stated in your affidavit dated December 16th, 2025, that on the last site visit, Morrisville Water and Light condemned one of the Adams poles due to rot beneath the surface, correct?
Due to what?
Rot beneath the surface?
Rot beneath the surface.
Rot.
Is that what
like-
you,
Yeah,
I don't know that it was condemned on those criteria alone, but that is present for sure.
and what equipment test or analysis was undertaken to determine that there was rot beneath the surface?
So what types of analysis were used to discover that rot?
Yeah, did you take a moisture reading? Did you, I just don't know what you did.
So the tried and true practice for decades in the line business for detecting is involves a couple of different things. There's the hammer test. You take a 3-pound hammer, you sound the wood at different levels and you listen to what is the sound.
Did you do that?
Well, yes, we did. And
During
visual
the site?
inspections.
During the site visit, you had a hammer?
Sorry, what?
During the site visit, you had a hammer?
Well, you're referring to that specific, the last time that
Yeah.
that day I met you?
Yeah.
The line foreman, who's about 6'4" and 250 pounds,
My question was just, did you
leaned
do
on
the
the
hammer?
pole, which is a standard practice. This is you can find this in the textbooks. It's a textbook description of how to test for rotten pole. Is you lean on that pole 90 degrees to the pole, and if there's any sway in that pole, you have a structural deficiency below the ground level, and that is a inspection that is taught in the line schools and utilized in utilities all throughout the nation, all throughout the world.
Was he
And
present at the
we
site
discovered
visit?
that happened when we were at the site visit.
So that person you're talking about, the line foreman, was at the site visit?
Yes, he was.
Were you on the Adams property in 2022, 2023, or 2024?
I've been there on multiple occasions and most likely 2022 and 2023. I'm not sure about 2024. When you say on the property, I mean just doing a visual inspection from the neighbor's property or actually being on the respondent's property?
I just want to establish that they permitted you on their property during those years, correct?
Yes, I have been.
So that sounds like relatively regular access to their property.
The question again, sir?
I'll strike it. When you have entered the Adams property, you always gave them advance notice, didn't you?
Not at all times, no.
And when you did give them advance notice, how much in advance were you able to notify them?
Well, when I've got trees on fire.
Yeah.
The advance notice is gonna be minimal to non-existent. When they're
Alright.
scheduled work, well, then we'll give them, as much time as possible. And you know, that is more likely going to be weeks out because that is a transmission line that requires scheduling to get the line out.
Okay, but so it sounds like there have been times though that you went on the property for whatever reason without being able to give advance notice to the Adamses. Fair to say?
That's fair to say.
And so you really have had access to the property even without an easement. Fair to say? Not the access you want, I get it, but you've had some access even not having an easement.
I would say that we have very limited access, Mr. Simon.
Thank you. And Rusty Shed was never made a witness to this proceeding. Is that true?
Not to my knowledge.
All right. Now, Morrisville Water and Light has stated it's only condemning the width of the easement to the boundary line of the Adams property, correct?
Yes, that's correct.
So there will be places along the corridor where your easement over the Adams property will be 10, 5, or even less feet in width based on the site plan, right?
On the Adams's property, that's correct.
And in those areas, you feel that that's an adequate width for the easement.
I'm sorry, the question again?
In those areas, that's an adequate width for the easement.
It's all that the respondent has authority to give Morrisville Water and Light as an easement, and they don't have any more land, so we wouldn't be seeking an easement other than from them. If they don't have that amount of land, 25 feet either side of the pole to grant us, then there's no need to go wider, right? We're getting 25 feet on the side that they have 25 feet, and on the side that they don't have it, what is available, we're asking them to make that a part of the easement.
I'm just going to interject that, Mr. Simon, you're down to about 10 minutes, so just giving you a heads up. You're muted, sir.
Thank you. To be clear, a defined path of entry is different from entering and passing over the property just anywhere, correct?
A defined path is different than,
Then an open-ended right to go anywhere you want.
yeah, we're not asking for the right to go anywhere we want.
But that's what the easement would give you, isn't it?
Objection.
We're asking
Let's keep the
for-
legal conclusion.
I'm not asking for its legal conclusion. I'm just asking for its
I feel like
understanding.
we've covered this
Yeah,
topic.
all right, I'll
ad
move on.
nauseam.
I'll move on. And I'm almost done.
Yeah.
So I'm just gonna skip over some things. So the easement that you're proposing, now strike that. These roads. If you just give me a moment, I'm going to consult my client and I think I might be done.
Okay.
Right now. Otherwise.
All right, so just to make sure the record's clear and so I can sum up where we are with your testimony, sir, I just want to see if I can summarize where things stand. Currently, you have 2 poles that are 40 feet tall, 5-foot cross arms, and you have the lines that go over those poles. And that's all that Morrisville Water and Light has, and that's all the impact you have on the Adams property. Is that a fair characterization?
Yes,
And what you're asking for by way of this condemnation and easement is all the rights that are contained within the easement, however we might interpret those, as you said, to the fullest extent that those could be exercised. Fair to say?
I think so.
And specifically what you're looking to do is go to a 45-foot tall pole with 10-foot wide cross arms. Fair to say?
Yes,
And you don't believe that that's in any way an increase in capacity?
I believe that's correct. It is not an increase.
And you say that not being an electrical engineer. Fair to say?
I say that not being an electrical engineer.
Thank you. Nothing further.
Sorry, I'm muted. Before we go to redirect, Wesley, did you have any additional questions for the witness?
I did, yeah, thanks.
Yep.
Hey, Mr. Heller, just curious back to the hearing officer's questions at the beginning about the condition of the pole and sort of business practices related to pole condition. Just curious, in your experience, how often you come across poles that are at a similar condition to those on the Adams property, and a typical practice with respect to assessing that poles are in that condition.
So fortunately, it's becoming less and less an occurrence on our system. And the bulk of them are all in a row, starting at about the village limit, which is just north of the Adams's property, south to the recreation path in Stowe. There was originally, when I took over as the superintendent or the working foreman, there was about 10 of these poles from the same 1940s generation. And I think we're down to like maybe 6 now. And there was poles from Shaw's grocery store, which is again just north of the Adams property. Going again north, we replaced maybe half a dozen poles, all the same age. And what we found was that one of them, which was right next to Route 100, that was being paved at the time with heavy equipment, was hollow and it had a lean to it. And this was discovered after we took it down, how bad the condition of that pole was. And we were just very grateful that we replaced it when we did, before all the heavy equipment came along, rollers, compactors, excavators, that kind of a thing. So this is a small part of our territory, and we're really trying to clean it up and make it part of a upgraded physical plan. Well, if I answered your question in its entirety, but I tried.
Yeah, thanks. Just to clarify, are you saying that in general, in Morrisville Water and Light Service territory, there are very few poles in this type of condition?
That's what I'm saying, yes.
And in general, to sort of bounce off the hearing officer's questions at the beginning, you would treat poles in this condition as priority replacements. Is that fair to say?
Absolutely, yes.
Okay, that's all I have. Thanks very much.
Okay, and I just have 1 or 2 more questions in there. They might seem a little bit of out of left field to people, so I'll just try to be really clear why I'm asking this. Because I heard Mr. Simon reference section 2913 of Title 30 and about whether or not the company had approval to provide service outside of the village of Morrisville and in Stowe. And I guess my question is, first of all, my understanding is that this line is a transmission line, correct?
That's correct.
It is not used to provide retail service to any customers in Stowe, correct?
That's correct.
Does Morrisville serve any customers outside of the village of Morrisville?
Yes,
Or
we
outside
do.
the town of Morrisville? I'll forgive, I understand that that is a delicate political situation that I might not know all of the ins and outs of. But what I'm getting at is, are you authorized to provide service in Stowe?
Yes, we are.
Oh, okay.
Yes, we have several, we have distribution customers in the village of Stowe. Well, not in the village, but in the town of Stowe.
In the town of Stowe.
Yes.
I'm assuming that those are somewhere near the border of Morrisville and Stowe in that northern area, or?
So our last customer is with less than a mile of the respondent's property.
Mhm.
We have numerous customers in Stowe, in the town of Stowe.
Okay. But those customers are not, I guess they're not served by this line directly. They're served by a distribution line that runs parallel to it or nearby it.
That's correct.
I see. Okay. Mr. Simon, since I realize that that's kind of a new topic that just came up, do you have any follow-up questions to that before we get to redirect?
Just give me a moment, please.
Yeah, no worries.
We'll brief the issue, and I just want to be clear that I'm reserving that issue on behalf of both my clients, not just Miss Adams.
Okay, understood. All right, Mr. Long, any redirect?
Just, I'll be brief. This is in relation to Mr. Skidmore's questioning. I think, Mr. Heller, you referred to an upgrade to the infrastructure. Are you talking about an upgrade in capacity?
No, sir.
That's all. Thank you.
Okay, nothing from the department?
I actually have a quick question along a similar
Okay.
line.
Yeah, I'm sorry. I should have asked that before we went to redirect, but go ahead.
Oh, thank you. Sorry. So a moment ago, a little while ago, you were asked a question by Attorney Simon about the operational advantages that the granting of this petition would provide that Morrisville Water and Light does not currently have. Would you like to elaborate on what those advantages are?
The major operational advantage is timely access. When I get a report that there's trees on fire, which means there's power going into the ground, which is an endangerment to the general public. And when that same report is resulting in damage to the wire, which decreases the strength of that wire and causing transmission outages, I have an obligation and responsibility to do something at the time that's reported. Timely access is what is going to give us the operational improvement that I'm seeking.
Thank you. All my other questions were answered, so that's all I have.
Okay, let's take a 10-minute break and then we'll move on to our next witness. Does that sound okay for everyone?
Sounds
Okay,
good.
see you all at 2:55. All right, are we ready to call Mr. Bailey and get on?
I believe petitioners are ready, and I think that's, yep, I see Mr. Bailey.
All right. Mr. Simon, are you available, ready to begin?
Yes, I am.
Okay, great. I'll dispense with the formality and I'll just say Mr. Bailey's been called. How about that? And Mr. Bailey, can you raise your right hands, please? Do you swear or affirm under the penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? You're muted, so you have to repeat it so the record has it. Still muted, sorry.
Oh, there we go.
Okay,
All right. I do
Can-
swear, yes.
thank you. Okay.
Can you please confirm for the record that you are Mr. Eric Bailey?
Yes, I am.
And Mr. Bailey, did you submit in this case pre-filed direct testimony on or about October 18th, 2024?
I did.
And do you adopt that testimony as your testimony today?
Yes.
That's all for me.
Okay, I don't believe Wes or I have any questions for Mr. Bailey, correct, Wes? Yeah, okay,
Nothing
so
at
then
the-
I think we can go right to Mr. Simon and begin the cross. Okay,
All right, thank you. Good afternoon, Mr. Bailey.
Hello. Yes.
I don't know that we've met, so in case we haven't, nice to meet you.
You as well.
So Mr. Bailey, you're the village manager of the Village of Johnson, is that correct?
That is correct.
You're also the general manager of the Village of Johnson Water and Light Department,
Yes, sir.
and you became village manager in September 2022,
Correct.
and you're testifying this matter for the petitioners, Morrisville Water and Light and Johnson Water and Light Departments, correct?
Yes.
And your testimony provides a general overview of the ownership of the line and relationship between Morrisville Water and Light and Johnson Water and Light.
It does.
Johnson became involved after it was determined that they need to be added as a petitioner in the case because you own 15% of the line.
I don't quite follow the question.
Were you aware that there was a previous proceeding in which Johnson was not a party?
Prior to, shortly before my testimony, I was not aware of that line, actually, no. Right, it was brought to my attention by Morrisville Water and Light and yeah, it was just one of those things that existed prior to me and never became, it never came out that it was something that I had to worry about. I just didn't know about it until, well, short before my testimony.
So you weren't, when the original petition was filed, you were not aware that that petition was being filed?
No,
But you acknowledge Johnson Water and Light Department does hold a 15% interest in the line that's the subject
I
of
do
this
acknowledge
proceeding.
that, yes. Yes,
And you were not employed by the Village of Johnson in 2014, correct?
I was not.
So that all makes sense now. So you did not negotiate the bill of sale or the quitclaim deed or the joint ownership agreement.
Correct.
And it sounds like you probably just learned of those since shortly before your testimony as well, correct?
That is correct.
And so you have no personal knowledge of what assets were physically inspected before Johnson acquired the 15% interest in the line?
I do not.
And the bill of sale, have you seen the bill of sale?
If so, I don't recall. I see a lot of paper, so it's possible.
So I'm sharing with you the bill of sale. I'm sorry if it looks, I'm looking off to the side as I'm using two computers here, so I don't mean to
I understand that.
here. If you,
I host meetings all the time.
here, I think I can, look you a little more directly. All right. So up on the screen is exhibit PET-EB4, the bill of sale. You see that?
I do.
And you have at this point reviewed that at some point?
Um,
This
probably.
was,
I'd say
well,
this-
yeah, it was attached to and filed with your pre-filed direct testimony, correct?
yes, in that case, I have. Yes,
All right.
it's been a while. There's been thousands of papers since then. So
And if I look at what is included in the bill of sale, it says it's a 15% interest in the seller's right, title, and interest in and to and under the assets, equipment, and items listed in the attached Exhibit A, correct?
yes,
And if you go to Exhibit A is a 15% interest in the 34.5 kV sub-transmission line that runs from Johnson Substation in Johnson, Vermont to Morrisville Station in Morrisville, Vermont, and then also a 15% interest in Morrisville's existing 34.5 kV sub-transmission line, known as the 3329 line, which is the subject of this proceeding, correct?
correct.
And then where it refers to further in Exhibit A, the Google map. And so could you read, you'd agree with me, right, that it refers to a Google map in the bill of sale? Exhibit
Yes.
A?
It does.
And could you read what it says on the top of page 2 of the bill of sale? I'm putting it up on the screen.
Morrisville does not currently have a record of the number of poles or the hardware associated with each pole. However, the line is visible and can be traced using Google Earth. A screenshot from Google Earth is attached for reference.
And have you ever obtained a further description of what is included in your, in Johnson's ownership?
Not to my knowledge, no.
Thank you. And, the village, of Johnson, I know it sounds obvious, but the village of Johnson's a separate and distinct municipality from the town of Morristown, right?
Yes, it is.
And there's nowhere where the village of where the town of Johnston touches the town of Stowe, correct? The borders don't touch.
That is correct.
And there's no portion of Stowe that's in the Johnson Water and Light service area, is there?
Also correct. There is not.
And Johnson Water and Light has never obtained any kind of authorization or permission from the PUC to operate in the town of Stowe, correct?
Not to my knowledge, no.
And when you obtain this 15% interest, you did extend your plant in some meaningful way into the town of Stowe, fair to say?
I guess that depends on how you chop up your 15%.
Okay, well, it's 15% in the whole, right?
If that's how it's worded.
All right. And you did not, well, you tell me, but I've looked at your bylaws. You don't have a state statutory charter, do you, Johnson?
We have our own charter that the state authorized.
Yeah. Bylaws, right?
Yep.
And those bylaws don't authorize you to condemn property in other towns, do they, to your knowledge?
They do not.
And have you seen the proposed easement in this case?
I believe I have, but I don't have recollection of it. It was several, many months ago.
I'm putting up on the screen right now, exhibit PETSJ Sup 1 is on the screen. Village of Johnson Water Light Department is not listed as a grantee in that easement, is it?
I'll assume it's not because you've already read it. And it's a lot of very small print.
Oh, it's on the screen. Can you see it?
I know, but it's a long, oh, I see at up at the beginning.
Yeah, the only grantee is Village of Morrisville Water and Light, not
Yep,
Johnson.
that is correct.
But Johnson has become officially a joint petitioner though, correct?
Correct.
And for the purpose of condemning the Adams property where the line exists?
For the purpose of being allowed to do the work necessary to, keep the line from collapsing. Yes.
And if at any time Morrisville Water and Light is unable or unwilling to do work, it's your understanding of your agreement with them that Johnson could theoretically do the work, correct?
Yes.
So if you're not listed on the easement, what rights is Johnson seeking to condemn from your understanding?
It's in my testimony.
So you have nothing else to add other than what's in your testimony?
Correct.
And do you know where in your testimony it refers to the rights that you're seeking to condemn?
Where? I mean, on the paper. That's
Just give me a moment.
okay.
I'll find it. All right. So here's your pre-filed testimony. You see that?
Yes.
So it says that your purpose of your testimony is to support the amended joint petition, right?
Yes.
And you acknowledge in there that Johnson holds a 15% ownership interest, correct?
Yes.
And the purpose of that acquisition was to avoid Green Mountain Power Service sub-transmission fees, is that right?
I believe that was involved. Yes.
All right. And then you say that you explain that upon the acquisition of the ownership interest, you entered the joint ownership agreement, and you talk a little bit about the ownership agreement, correct?
Correct.
So I don't see anywhere in there that you discuss what rights you're seeking to condemn.
I guess I don't.
All right. Thank you.
Yep.
And the amended petition does not state, to your knowledge, does it, that Johnson Water and Light Department owns and operates a distribution system serving the town of Stowe, or 15% of the system? And if you don't recall, I'll just
I
rely
don't
on
recall.
the petition.
I don't recall.
All right. Are you aware of the Title 30, Section 2913 requirements for extensions into other municipalities?
I can't quote it. No.
Yeah, well, without chapter and verse, are you generally aware that in order to operate in another municipality, usually municipalities are required to obtain PUC permission?
Yes.
And Johnson's never obtained that kind of permission to operate in the town of Stowe in any manner, correct?
Correct.
Your testimony states that just a moment. I'm going to skip over some stuff. So, I'm taking a minute. It's going to go faster if you just let me. So Johnson pays Village of Morrisville for property taxes in proportion to its ownership share of the line. Is that correct?
Correct.
And Johnson pays a proportionate share of operation and maintenance charges?
Correct.
And you obtained Johnson obtained a PSB order in 2014 authorizing Johnson to finance its 15% ownership stake in that line, correct?
I'm just gonna
I'll
object
assume that's
because
correct.
I'm not sure
Go
where
ahead.
we're going here with relevance. It seems like we're getting a little off track from the necessity issues.
All right, I'll withdraw the question. Do you believe that Johnson is an indispensable party in this proceeding because of its 15% ownership interest in the line?
Not really. But, I mean, we just, pay for a portion of the maintenance. We don't, none of our people have ever been over there. So we've never even laid eyes on it.
But as a petitioner, you're seeking condemnation relief in the case, correct?
I'm just seeking the ability to, keep the line running so the lights stay on.
And based on your service agreement, if you had to, John, your understanding is that Johnson could go and do work on the line if it had to, right?
Objection. I think we're retreading at this point.
If I asked that question already, I'll withdraw it. Was that asked and answered?
Yeah, I think it has. That's my understanding.
That's fine. I withdraw it. And you're not offering a legal opinion about Johnson's condemnation authority, are you?
No,
And was there any vote by the Johnson trustees to approve the participation of Johnson in this condemnation proceeding?
I couldn't tell you. That happened 8 years before I got here.
No. All right. So I apologize. I that was inartfully worded. What I was asking was, after you were asked to join the petition, so within the last year or so, prior to November, I guess I would just say, prior to your participation in this proceeding, was there a vote by the Board of Trustees to approve this condemnation and Johnson's participation?
No,
Why not?
it was within the authority of the general manager to make that decision.
So you don't believe that a Board of Trustees vote is necessary for the town of Johnson to participate in the condemnation of land in another jurisdiction?
I thought you said that my paperwork didn't show condemnation. It just showed a partial ownership.
Well, you're a co-petitioner in the condemnation, so I guess.
Well, when it's just when the, I guess in my point of view, the petition was to do what is necessary to keep hundreds, if not thousands, of people from losing power. I can do that. Yes.
What led you to that conclusion?
That's my job, to keep the lights on.
All right. You misunderstood me. You don't have any personal knowledge that this petition is necessary to keep the power on for thousands of people, do you? That you heard that from someone else.
It's a 34-5 line that, is a major trunk. So if the poles can't stand up, that it's a pretty obvious conclusion.
Have you ever been out to the property and looked at those poles? I think you said you've not ever been.
I have
there?
not. I most of what I've heard about it was in testimony shortly before I came on just now, but I also was told it by Morrisville, who had eyes on, and who I've trusted and have never given me any reason not to trust.
All right. Do you have any intention of having your Board of Trustees ever ratify or approve Johnson condemning property in the town of Stowe?
if, you know, if we have to go do something like that, I would absolutely be talking to both the board and the PUC, but, you know, it was my understanding as just a minority owner, I was just signing on to, you know, help keep the lights on.
So you don't view this as Johnson condemning property in the town of Stowe, even though you're a 15% owner?
I don't, because, you know, at 15%, I don't have a whole lot of authority.
All right. And so Morrisville Water and Lights ownership is only 85%, right?
Right, and, you know, I consider percents as votes. So it's just
Okay.
like a board, it's just like on a board of directors.
So
You know,
if you
you've got
and I
51%, you got the control.
so if you and I owned a camp on a lake together and I owned 15% and you owned 85%, you'd think you could sell the camp without my signing off?
The objection, we're posing hypotheticals at this point.
Yeah.
We move it forward.
More broadly, I'm just kind of struggling with this
I'll
whole line of question. I'll also just mention you got 10 minutes left for this witness, so let's try to move to the end of this.
Johnson doesn't have any recorded easements over the Adams property, correct?
Obviously.
And your acquisition of the 15% interest in the line had value to the town of Johnson, right?
Yes.
So you acknowledge an economic benefit from owning a portion of the line, correct?
Only by avoiding fees, but yes. Yep.
Thank you. Nothing further.
Okay. Any redirect or any questions first from the department? Sorry.
Thanks for asking. No questions from the
Okay.
department.
Any redirect?
No, thank you for your time, Mr. Bailey.
Thanks.
All right. Thank you, Mr. Bailey. You're dismissed. In the original schedule, I had proposed we did have another break, but that was assuming I think a longer session of cross. Do we want to just proceed to the Adams, the final witness panel for the day?
I'm happy to go ahead. I do not have very long.
Okay. Mr. Simon, is that okay for you?
We need about 5 minutes at least, preferably 10, if we could take it.
Yeah,
Just
we
because
can take a 10-minute break, especially if the planned cross is not extensive. We have a little over an hour left in planned time. I can run a little bit past 4:15, but I've kind of got a hard stop due to childcare requirements after 4:30. So we'll come back at 3:30, and hopefully we can get everything done in an hour.
Thank you.
Thank you.
Thank you.
I can't hear you.
I probably was just muttering to myself and moving my mouth. I hadn't turned on my mic yet. Okay, I think it's almost 3:30. We are the Adams ready? Can turn their camera on. Good afternoon. It's nice to meet you in person or virtually. We might need to turn off, one mic. Thank you. That's great.
Go ahead and turn yours on. Cool. Does that not work?
That sounds good.
Hold on.
Maybe volume.
Well, I think we're using a different mic in the. All right, I don't think we're.
I think because you guys are in the same room, it sounds like you just may need to keep one of your microphones off while the other person is speaking. So for this, and I know that's going to require a little bit of a dance. So how about I ask the questions, Mr. Simon, just to get them ready so that we're not trying to do that. So we'll say that the Adams have been called to the stand, and I'm going to ask you both to raise your right hand right now, okay? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
I do.
Okay, thank you very much. And because you guys are testifying as a panel, I'll give you a special instruction that only one of you has to answer the questions. However, if you have an obligation to speak up if you hear the other person on the panel say something that you don't agree with or that you think is a mistake. So while only one of you has to speak, understand that their answer is being attributed to both of you. So with that instruction out of the way, I will just confirm that you are Lesley and William Adams, who have presented pre-filed testimony in this case.
Yes.
That's correct.
Okay.
So we have technical feedback.
Okay.
We're not hearing you, and I don't believe you're hearing us except through an echo.
Yeah, it's all coming through my computer, and it's not for some reason going through their computer correctly. And so
Okay.
that's what's causing the problem. Can we just use this one?
Yeah.
This same thing. I just don't think we're gonna be able to make that work.
Yeah, I can hear you right now. You sound clear.
Can you hear? You can hear us?
Yes, sir.
Yeah, I think
Can you
we're
take that
good.
away then?
We're good.
That's
Take that
working
away.
now.
Yeah, great. Thank you.
Okay. So I think with that out of the way, we'll turn this over to Mr. Long to begin the cross-examination.
Thank you. Good afternoon, Mr. and Mrs. Adams. How are you?
Good, thank you.
Good, thank you.
I appreciate your sticking with us all day. I just have a few questions. Hopefully we can get through this quickly. First of all, do you own the property located at 53 Cemetery Road in Stowe, Vermont?
No, we don't.
Oh, who owns the property?
You said who owns the property at 53 Cemetery Road. That's not the correct address.
Okay, what's the correct address?
58 Cemetery Road.
At 58 Cemetery Road, are there two transmission line poles on that property?
Yes, there are two transmission poles, or two wooden poles, I should say, on the property.
And in your own words, where are those poles located on the property?
The poles that are the wooden poles are located in an area of our property that sits at sometimes 30 feet from our boundary to almost 0 feet from our boundary. So the two poles are located along that line, and they're proximate to our boundary at different distances from the boundary.
Are you referring to the southern boundary of the property?
I would say that it's not exactly southern, but it is more southerly.
Thank
It's
you.
not northern, it's not eastern nor western, but it's not true southern either.
That's helpful. Thank you. When did you become the owners of the property?
I have a quitclaim deed that's in the record that identifies the year that I became an owner title. Mr. Adams has owned the property since 1997. And that is also referenced in the documents that are in the record.
And who owned it before Mr. Adams owned it?
The property was owned by Mr. Adams's father, Curtis Adams.
And do you happen to know when Mr. Curtis Adams became the owner of the property?
Mr. Curtis Adams became owner of the property in the early 80s. And then after his death, the estate was transferred to the children of Curtis Adams.
Okay. And the poles that we talked about, I think you referred to them as wooden poles.
Yes.
Were they there at the time that Mr. Curtis Adams owned the property, if you know?
Well, I personally can't speak to that, and I know that Mr. Adams can't speak to that because neither of us owned the property. There are obviously poles on our property today, and there were poles on our property when Morrisville Water and Light filed the condemnation petition. There were poles on the property when I first visited this property, but that's all I can basically testify to.
Okay, so you don't have personal recollection of there being wooden poles on the property prior to your ownership of the property, is that correct?
That's correct.
And is that the same for Mr. Adams?
Yes, that is the same for Mr. Adams.
Okay, I'm going to start with showing you a couple of exhibits, and I'd like to primarily get oriented to the property because I wasn't able to go to the site visit, and I believe it might be beneficial just for us to understand a little bit about your property. So hold on while I share that. Okay, I'm showing you what was previously identified as Adams Cross Exhibit DD. Can you see that okay?
Yes, I can see that. And
Okay,
Mr. Adams can see it too.
and if at any time you need me to blow it up, I'm happy to do that. Just let me know, okay?
Thank you.
Do you recognize this picture?
Yes,
Do you know who took the picture?
the landowners took the picture.
Would that be you, Mrs. Adams, or Mr. Adams?
I believe that was me.
And let the record reflect that was Mr. Adams.
Yes, that's correct, Mr. Adams.
Okay, and on the far right of the picture, I see a pole. Do you see that?
Yes,
Is that one of the poles we've been talking about today?
That is one of the two poles that is on our property, yes.
And I also see a fence. Do you see that?
Yes, I can see the fence.
Do you know how tall that fence is, running from left to right along the middle of the image?
That fence is a 8-foot fence approved by the town of Stowe.
Thank you. That fence, is it on your property line?
It is within the property line.
Okay, do you know how far beyond the fence your property line extends?
The property line extends at various widths beyond the fence because the property line varies along its length in terms of how the fence is situated in relation to that boundary. At places it's actually 6 inches, at places it is 12 inches, at places it sits 1 or 2 inches from the property line. It varies in terms of how the actual fence was constructed.
Thank you. That helps give some scope. Thank you. I'm going to show you what was previously admitted as Adams Cross Exhibit EE. Do you see that?
Yes.
yes.
And do you know who took this picture?
I believe it was myself.
And is this the same pole that we were just looking at in the previous exhibit?
Yes, it is.
And is it fair to say that this picture is a view to the south of your property?
That is a picture towards the southerly direction of our property.
Now, there's another pole on the property, correct?
There is another pole on the property. Yes, that's only one of the two poles.
Okay, I'm going to show you what was previously marked as petitioner's pre-filed testimony of David Heller at Exhibit 2. And I'm going to go to the picture part of it, and then let me know if you can see that or if you'd like me to zoom in.
I'm seeing that.
Yeah, I can see it.
Can you tell me what we're looking at?
We're looking at something that says December 1st, 2015. And what we're seeing is we're seeing some windows, a building, something white, which I can't identify. I'm seeing a piece of wood, can't identify that. That's what I see.
I believe you heard testimony earlier from Mr. Heller that Morrisville Water and Light was on your property in late 2015. Did you hear that?
Yes, I heard that Morrisville Water and Light was on our property in 2015, yes.
And I understand you may not be able to identify everything in this photo, but do you have any reason to dispute that this is a picture of the cross arm of the pole that we were all looking at in exhibits D, D, and EE?
In December 2015, I don't have any personal knowledge of a photograph being taken, and I did not take that photograph. Do I have any grounds to dispute? I don't have any reason to say that that is not a picture that Morrisville Water and Light took, but I did not observe it. And I did not observe it because I actually was not in the United States at that time because I was abroad.
Thank you. The buildings in the background, and I understand if you don't know, but if you do, can you identify those buildings?
From the picture, I can't see the buildings entirely, but I am seeing windows, and those windows may in fact be similar to the windows that we have on our property, but it's not clear because of the way the title is across it. So I'm not seeing the full building, but I do see windows, and they do have a similarity to the windows that we have in our property.
Okay. Let me ask you about the line itself. Are there any structures beneath the line on your property?
Could you define structure for me, please?
Sure. Any residences, outbuildings, sheds, carports, anything of that nature?
When you say anything of that nature, is that because what you've described was just, 3 or 4 examples? Can you expand your list so that I might be able to have a better ability to actually respond?
Unfortunately, I think we'd be here all day.
Structure is a very broad definition. I just want to make sure that I understand what you mean by structure. That's all. It's a very broad definition.
Sure. So building off of that, why don't you tell me if there's anything under that line that you would define as a structure, and then define structure for me?
I don't think I'm in the position in the middle of this to provide a dictionary definition of the word structure. I'd like to be able to do that. If you could rephrase your question to basically ask what you have underneath if you ask me broadly, generally, to describe in its entirety what is actually under the line that's on our property, I will be able to give you that broad, inclusive description, and you can then determine what you think is a structure from that list. I can describe it for you.
We'll save that for later. Let's move on. Are there any trees near the pole we were looking at in the first 2 exhibits?
Are there any trees near the poles in those first two exhibits?
Yes.
I saw numerous trees, but I don't know what you mean by near the poles.
What about the pole we didn't look at? Are there any trees near that other pole?
There are trees along the boundary of our property, and so there will be, and there are trees that are growing along the boundary. So therefore there will be trees that will be in line with where the transmission line is. So there are trees on our boundary.
Do you know if there are some trees to the north side of the line?
When you say north side of the line, do you mean on our property or off our property?
On your property. My understanding from your previous testimony is that the line runs essentially the southern portion of your property. I'd like to know if there are lines near the pole on the north side of the line.
You know, we have 12 acres here. We got trees all over
everywhere.
this
So
property.
please help us be
So
specific.
the answer to your question is yes, there's trees on the northern side of the property.
Thank you. I'm showing you what was marked previously as Morrisville Water and Light Cross Exhibit 1. Do you see that?
Yes, I see that.
And can you tell me if this is an accurate depiction, and I'm referring specifically to the blue shaded portion of this photograph, if that's an accurate depiction of your property?
Accurate is not the right word. I'd say it's an approximate, but not accurate, because it is not a land survey. And it's an aerial overlay. And so therefore it's a computer generated, topography generated image, and it's not accurate.
Okay, and where do you take issue with the accuracy of the photograph that you're looking at?
I take issue with the accuracy in how it actually sits in relation to Cemetery Road, how it sits in relation to 53 Cemetery Road, and how it sits in relation to the northern border where it abuts 605 Maple Street.
Let me ask you, there's a red line running through the blue portion and some of the other properties in this photograph. Do you see that?
Yes.
Is that red line accurately depict the transmission line running through your property?
I can't answer that. Doesn't have any identification on it. And I don't know if it I can't attest to the fact that it accurately depicts anything. It's a red line.
Would we need to look at your own surveyor's survey to determine that?
I think it would be helpful to look at an accurate survey, yes.
Okay. I'm showing you what was previously marked Landowners Exhibit Adams Supplemental Rebuttal Testimony number 2. Do you see that?
Yes.
And do you recognize this document?
Yes.
And can you tell me what it is?
That is a boundary survey conducted by surveyor Patricia Coulis from Little River Survey, and it is a certified survey of the Adams property at 58 Cemetery Road in Stowe.
And did you hire Ms. Cool's firm to perform this survey?
The landowners hired Patricia Coulis to conduct this survey, yes.
To be certain, the landowners is you, Mr. and Mrs. Adams, correct?
Yes,
Correct.
the landowners as jointly Mr. and Mrs. Adams, yes.
Thank you. As you look at this survey, and I'm happy to zoom in if it's helpful, are there any structures that Ms. Cool's left out of the survey on your property?
You would need to zoom in for us so that we can actually look at that.
Is this close enough or do you need me to go further?
So structures, again, it comes back to what do you mean? What I identify and what I see is a residential driveway. I see parking spaces. I see what would be described as a wall. I see, you haven't shown me the whole of it, so what I can see right now is I can see a sewer line. I can see electricity poles that are not belonging to Morrisville Water and Light. I see, and you haven't shown me the full extent of it, so I can't comment on what's at the either end of what you're showing me. I see.
Is there anything at the other end of what I'm showing you?
I don't know until you let me see it. I believe that there are.
Here you go.
So there's nothing there. Can you go to the other end just so that we can be 100% certain?
Of course.
So what I see that is marked on that is fence. And if you let me see the actual legend, I'll be able to identify exactly what those things are. So yes, Ms. Coulis has identified a number of pieces of infrastructure, I would call them. Infrastructure including fencing, infrastructure including electrical lines, electrical poles, sewer lines, and then under the line itself there is a driveway which is depicted, and there are obviously cutouts which represent parking for residential buildings. That's what I see on that.
Okay. And does this survey depict Morrisville Water and Light's proposed easement in this case? And if so, could you tell me where?
Let me just see, can you go to let me see the title of that, because there was two that was submitted by Ms. Coulis. One was a land survey and one was a survey with the overlay of the proposed easement from Morrisville Water and Light.
Are you referring to the title on the left boundary of this document?
Yes, so that would be the one with the proposed easement. I think that if you again give me the legend, you'll see that the hatch marks have an identification that they're identifying the proposed easement.
And you're referring to the last entry in the legend proposed easement, and then as
Yes.
the
Yes.
hatch marks. So it's fair to say that there are hatch marks, and your surveyor is indicating that relates to the Morrisville Water and Light proposed easement.
Yes, as described in the revised easement.
And let me zoom in. I see a house. Do you see that?
You'll need to sort of say specifically, are you looking at the footprint that actually has the word house on it?
Yes.
Yeah, okay. It's just that I see a house, a residence and a barn.
Okay. We have residence and house. Is there a difference between those two buildings?
Yes, indeed there is. The house is just by definition what we call the main house. The residence is a second residence, a 3-bedroom residence that we own, that's on our property. We have in our zoning the capability of having more than one residence on our property, and that is marking a residence.
And I also see a barn. Do you see that?
Yes, the barn is marked also.
And do you see anything else along the lines of house, residence, barn, shed, anything like that on the survey?
Well, it's a sewer line.
Yeah, no, the thing that's on the remainder of the northerly end is the town of Stowe's sewer line, and there are lateral connections to the sewer line that cross onto our property, and there's electric service line pole that's depicted on that sits just on the property boundary that belongs to the town of Stowe also.
Okay, thank you.
which provides our primary power feed to the residents, the barn, and the house.
Thank you. No further questions from me.
Okay, anything from the department?
I have no questions. Thank you.
Any redirect, Mr. Simon?
Just briefly, do you make any use of the westerly portion, southwesterly portion of the property in the location where the easement is proposed?
If the gentleman from Morrisville Water and Light, representing Morrisville Water and Light, would kindly put up that survey again, I would be more able to answer that question. So if he would be able to reshare that survey, it gives the opportunity for everybody who's on this call to basically.
I can share it.
Can you share
Yeah.
it? 'Cause
Well, I hate to do this, but I have to object. I don't think I made any discussion about the use of land in the westerly or anywhere else. I don't know that's the scope of what we're talking about.
I'm talking about within the easement area.
just give our Mr. Simon the opportunity to share that again, and I will be able to answer that question fully.
Objection is overruled. Yeah, I know we're trending a little out of scope, but I'm going to be liberal here. So let's just look at the map and let's find out what's happening down there in the corner.
Yeah, I'm talking about this area here.
Can't see it just yet, so.
I can't see the survey map yet. There's no survey map shared yet.
Not sure.
No, I don't see it.
Hold on. How's that?
No.
In the interest in expediency, I'm happy to put it back up.
Thank you, sir, if you can, yeah.
I should be right. For some reason, it keeps on not letting me. I think that,
Okay.
I'm talking about.
If you could zoom out for us just a second, just so that I can just orientate those that are. Mr. Simon has asked a question. To answer that question, could you zoom out again, please?
Outer in.
Okay, so to answer Mr. Simon's question.
So I'm talking about the bottom left portion.
Towards Cemetery Road.
Of,
Yes, towards Cemetery Road.
Yep,
Okay.
that's also all the way towards Maple Street. So where the crosshatch section where it shows that it's part of the proposed easement, right there where the hand is.
Oh, okay, all right, I see that.
Do you make any use of that area of the property?
We make considerable use of the entire length of that boundary. That is a primary driveway. It is a storage area. It is an area where we have materials, we have property maintenance equipment that's necessary to maintain a dirt driveway. We have other instruments that are stored within an area that was constructed under a permit. We have a retaining wall that supports a collapsing bank. We have a storm drain system that sits there because the properties above us on Maple Street basically, unfortunately, have a stormwater runoff issue that the Director of Public Works from the town of Stowe is
I'm not asking you.
that's what's on that area.
No, I
Storm drain
understand.
system.
You just can't talk about what the town of Stowe told you. But is there an enclosed area in that section of the property?
Part of the fencing has a gate, and within that area we have a number of implements that we use to maintain our driveway, to maintain our lawns, to maintain our property. There's materials stored because we have a building that we're currently working on, so we have materials stored because we are in the middle of constructing that residence. So we have in that area a multitude of different things that are all part of how we utilize our property. Our property is very much contained within that footprint right at the line to the westerly side of the property. So what is sitting there is a highly utilized, highly improved part of our property, and we use that daily, multiple times a day. That is a highly utilized part of our property.
Nothing further.
That's all the questions, Mr. Simon?
That's my only question, yep.
Okay. Mr. and Mrs. Adams, thank you for participating today. I appreciate you taking the time. That concludes the testimony and cross-examination portion of today's hearing. Before we adjourn, I'm just going to mention that I already issued a schedule for the briefing in this case. If you all would indulge me, I'd like to offer some thoughts about the briefs. And my thoughts that I'm going to give right now are not rulings, not determinations. They don't even reflect any prejudgment on these issues, but I have reactions to some of the information that's been presented today. And so I want to make sure that the briefs address areas that I have questions or that I'm interested in. So I want to give some, I guess what I'll call, breadcrumbs for you all to hopefully pick up and follow, and that this will help me make a more informed decision or a recommendation, a more informed recommendation to the commission. So I guess the first thing I'm going to note is that, in preparing for this case, I've been reviewing the matter of the Plouffe condemnation, which was docket 80, let me make sure I get the number correct here, 7819. So docket number 7819. And you can find documents related to that case in EPUC. Under the All Other Documents tab, you will see a copy of the final easement that was actually adopted or recorded in the land records in that case. So that's the only example I have of an easement that, according to the commission, passed muster, under 111A. And also, you'll see in reviewing that Plouffe case, the hearing officer recommended certain changes to the proposed easement document, and those changes ended up being adopted by the commission and being reflected in the final copy that was filed in the land records. Now I understand, Mr. Simon, that you intend to lodge larger legal arguments about necessity and also about the appropriateness of the entire petition. I'm not prejudging any of that stuff, but to the extent we get to, if we get to the question of what is in an easement, I would request that the parties provide actual copies of their proposed easement language. And in doing so, I would ask that you look at this easement document that was adopted in 7819 and explain why you're changing the language that's in there. And there are a couple parts that I'm focusing on. Some have been discussed today. First of all, I think I would expect that both petitioners would be listed as grantees in the document. The second thing, and I think this was mentioned earlier in this case, the language in the first paragraph about the conveyance, the sort of magic legal words. The commission's preference is that if an easement is required in this case, that the easement language reflect the involuntary nature of the condemnation. And you'll see language in that first paragraph that reflects that. It talks about remise, quit claim, as opposed to convey, sell, or something like that. So I'm not saying you have to put it either way, but I'm saying if you're going to do it differently than what we did in the last case, explain why. The next area is access. There's been discussion of access. I note that this Plouffe condemnation easement describes the access in detail, more detail than is included in the proposed easement. So, again, if you're not going to provide specific access, explain why that's necessary or why that's appropriate, or otherwise, please specify how the access is going to happen. Then the last thing, I'm interested in this issue of the sewers. I'm sure there's a wealth of case law either in Vermont or in other comparable jurisdictions about what happens when you have two easements in the same location. And my vague unfortunately receding into distant history, bar exam recollection, is that the bar exam answer is if there's two easements that run earlier in time controls. But that might not be the case. I'm asking you, scratch that itch for me in your briefs. And furthermore, it's not clear to me whether Morrisville is actually requesting to condemn those easements. They're trying to get property rights on the land that sits on top of those easements. It's not clear to me whether you're actually trying to interfere with those easements, and maybe additional language in the easement document making clear that the rights of the sewer easement holders have not been disturbed is appropriate, and would resolve some of the concerns that have been raised in this case. Lastly, obviously, I understand that there's quite a bit of concern about the status of some of the existing improvements that are on the property, the wall, the fence, the retaining wall, the driveway. If the petitioners, to the extent you don't find any of those existing features objectionable and you're not proposing to change them, then perhaps the easement should specify those portions of existing uses that are acceptable, so that any other broader language isn't misinterpreted as authorizing the company to remove those things. Last thought. I know that there have been some disagreements between the parties here, and I understand that this is a uncomfortable position for the landowners to have this sort of forced on you, and I appreciate that. But I would still like to encourage the parties to consider trying to negotiate easement language that you both find acceptable to each other. Obviously, the commission stands ready to make a decision about what needs to be written in an easement if one is appropriate and meets the statutory standards. All of that still has to happen, but I always advise parties in cases like this, if you can come to an agreement on this stuff, it can be better for everyone. And I hope you can still have that conversation while you're briefing this case. And if you can present language that is agreed upon, that could resolve some of this in a more efficient manner than us having to litigate every detail in that document. Other issues that I'm interested in for the brief. Mr. Simon, I heard you discussing issues potentially about the legal authority of municipal utilities to condemn land outside of their service territory. When you're making that argument, if you make that argument, I'd like you to address the applicability of Section 110, which generally lays out the eminent domain power of public utility companies in Vermont. So that's just one question I have. Other issue, I heard some rumblings about maybe the municipalities haven't dotted all their I's and crossed their T's with respect to their internal procedures for authorizing certain work. If that kind of argument is going to be advanced, we need to look closely at where the commission's jurisdiction lies with respect to enforcing those kinds of rules. We certainly have jurisdiction over utility matters. Section 209 lays out our general jurisdiction, but there is case law out there. I remember, I can't remember, it's Westover v. Barton. The commission can't make general pronunciations about the legality of municipal charters and things like that. So, because we're not a court. So, not saying that those might not be problems or issues, but we just might not be the right place to address them. Just make sure that if you're going to lodge those arguments, explain why we can address them or why we need to consider them in reaching a final resolution to this case. I tried to write everything down, but here in a minute. I think that's my laundry list of stuff that jumped out at me during the course of this hearing. So are there any other questions or issues that we need to resolve here before we adjourn for the day?
So, and I'm just going to bring it up and see if it goes anywhere. You tell me if it doesn't. We had our declaratory ruling sequence, and I believe the hearing officer essentially reserved on that until evidentiary hearing. Do you want further briefing on that issue, or is that kind of going astray? Save your pages for the other stuff.
No, good question. And I think now is the time. And the reason why I deferred ruling on that is because I kind of view these two questions is bound in linked in a certain way, in that I don't think I can interpret section 111A-C, or whichever the one that talks about necessary maintenance. I can't interpret that in a way that grants the company more rights than they could get through the condemnation itself. And so I think there needs to be an explanation as to why, why are the proposed I don't want to characterize them at this point, but the proposed work, why is the proposed work consistent with the scope of the easement that's required by statute? The statute says it can't change the land use in a material way, et cetera, et cetera. So I want to make sure that I'm not saying, oh yeah, you can do maintenance that even though it has a significant impact under the section 248 criteria. At least that's how I'm reading it right now. If I'm wrong, explain to me why I'm wrong. But yes, I do think that topic is in bounds at this point. I will make a recommendation on ruling on that motion for a declaratory ruling in my proposal for decision.
Thank you.
Yeah, and just to note, I'm not inviting it, but I want to. There isn't a page limit on briefs and proposed findings and facts, so you got room to address all of this. Don't you know? But that said, I always appreciate a brief that's to the point and succinct. So. But I think you have pages to address both issues here.
And just procedurally,
Well, I'm sorry, I didn't hear the last part of that. You're still muted, sir. Sorry.
I just want.
You're muted again.
Yeah.
All right, sorry about that. We're balancing the machines. From a procedural standpoint, are you saying you're going to make a recommendation to the commission and then the final decision will be made by the commission? Or do you make a decision and then we have to appeal to the commission if we don't like it?
No, so I'm going to misquote the statute, but one of the various sections of the APA says that basically when an employee of the appointed authority here's a case, I have to issue a proposal for decision for comment and opportunity for oral argument before the commission. So what's going to happen is after the briefing, I'll review all of that and I'll write up what's called a proposal for decision. It'll be circulated to all the parties. You'll probably have a couple weeks or 30 days. I don't know how much, probably depends on how complicated the written decision is, to file comments on it and to request oral argument with the commission. The commission will review your comments or any oral argument that you have, and after that, they'll write a final order. And that final order would obviously only address the decision on necessity. If they find that necessity has been demonstrated and they approve an easement document, they would probably then either elect to set a hearing date for a question on compensation or remand it to me to do so. I don't know what they're going to choose to do after that. But obviously, if they find that necessity hasn't been demonstrated or there's some other legal defect in the case, they would deny the petition, and that would be the final decision that could be appealed to the Supreme Court. So, if things didn't break in favor of your client, Mr. Simon, you wouldn't have that appeal right until both phases of the case had been resolved, the question of necessity and compensation, and then there would be.
Understood. It was just my recollection that you had to request the hearing before the commission. It wasn't automatic.
The oral argument?
Yeah.
Yeah, you have to request the oral. If you don't request oral argument, they'll just read your brief or read your comments and then render a final decision.
All right. Thank you.
Last thing that I wanted to mention. So this proceeding has been recorded by Teams. It generates an automatic transcript. I've been looking back at it as we go through this case. It's pretty good considering the technology, but it's not super accurate. There are parts where it garbles what we've said. That is going to be made available to you by email in a day or two. If you would like to request that the commission have a court reporter transcribe this, it will be at your expense, and you need to file that request in writing with the clerk. And I would recommend doing that as soon as possible because it takes 4 to 5 days for that process to happen. So, you would be getting it with a week to go before your initial brief is due. So I would get that request in today or tomorrow, as at the latest, if you need that written, if you want a court reporter transcription of it. You will have that AI generated one in a day or two, and usually that's pretty good for letting you know what like the subject that's being discussed, but there might be parts where it's kind of gibberish. And you'll have the video, which you can consult too. I mean, you can always, use the transcript to dial in on what time frame you're interested in, then rewatch the video to see what was said. Any questions about getting the transcript?
Not from me.
Okay. If Wes, is there anything else that I've missed or that needs to be addressed right now?
I saw Mr. Swain unmuted his mic for a moment. Just wanted to make sure nothing further. There's nothing from me. Thanks.
No, thank you.
Okay. With that, then we are adjourned. Thank you, everyone. Have a nice afternoon. Oh, well, hold on. I see a member of the public, Ms. Smith, has raised her hand. Yes, Ms. Smith, what can I do for you?
Yes, I just wanted to point out that at an evidentiary hearing last week, the question was raised about what is the official record, what to cite to, and the answer from the hearing officer was that the video is the official record and to cite to the time stamp on the video.
That is correct. Thank you very much for pointing that out. I appreciate that, Ms. Smith.
You're welcome.
That's helpful. Thank you.
All right. Thank you, everyone. Have a nice afternoon. I'm going to stop the
Thank you.
recording now.
Thank you.